Welcome, everybody. Thank you for coming to the 7th Annual Powell Lecture. My name is Ryan Germany. This is Rob Reed. We are the co-chairs of the Powell Lecture Series this year. I have the pleasure of introducing our speaker tonight. But before I do that, I do have to thank a few people. The Powell Lecture Series board, every one of them has worked diligently since last spring to make this happen. So thank you all very much. Dean Smola, thank you for your support throughout this process. Professor Murchison, every year, Professor Murchison is instrumental in making sure the Powell Lecture happens and is a success. So thank you again for your help this year. While sitting on the Supreme Court, Lewis Powell invited Washington Redskins running back Larry Brown to his chambers. And Larry Brown asked him, "Justice Powell, do you prefer being a lawyer or a judge?" And in response, Justice Powell said, "Well, would you prefer being a football player or a referee?" And today, we have the pleasure to hear from one of the great players in the legal arena. Carter Phillips, the managing partner of Sidley Austin in Washington, D.C., has argued 65 times in front of the nation's highest court and many more times in front of other appellate bodies. According to the National Law Journal, he has become the go-to attorney for corporations seeking Supreme Court relief. He's been named one of the 100 most influential lawyers in America and one of the 90 greatest Washington lawyers of the past 30 years. Recently, he received the Lewis F. Powell Award for Business Advocacy from the U.S. Chamber of Commerce. Mr. Phillips graduated summa cum laude and Phi Beta Kappa from The Ohio State University and received his J.D. from Northwestern, where he graduated magna cum laude and was inducted into Order of the Coif. He clerked for Judge Robert Sprecher on the U.S. Court of Appeals for the 7th Circuit, and then for Chief Justice Warren Burger on the U.S. Supreme Court. We are honored to have him with us tonight. So please join me in welcoming Carter Phillips.
Thank you, Ryan. I appreciate that very much. Let me say that it is obviously an honor and a pleasure to be invited tonight to deliver the Lewis F. Powell Lecture here at Washington and Lee. I thought since I had the privilege of actually knowing the Justice, I might start by making an observation or two about those experiences as a link between the Justice and some effort to deal a little bit with substantive legal issues as part of this lecture and hopefully tie them all together in a more or less nice package. I first met Justice Powell in 1977. I was clerking at the time for Judge Sprecher on the 7th Circuit, and I had applied to all of the justices. And I was fortunate enough to get an interview with Justice Powell. So I went to Washington. I sat down with him. He served tea and cookies. We had a more than an hour-long conversation. He was incredibly gracious. As I recall the conversation, which I have to admit, as a relatively young lawyer at the time, trying to keep track of these things is a little difficult to do over the years. But my recollection is that we talked mostly about foreign policy issues because that was one of the subjects that Justice Powell had a fascination with. And I had had the benefit of getting both an honors thesis and a master's degree in foreign policy issues and, as an undergrad and graduate school. And so I think that's mostly what we talked about. And I walked away thinking that was one of the best interviews I've ever had in my life. I had no idea whether you get the clerkship, because getting a clerkship is a lot like lightning striking, except the experience is slightly more positive, obviously. And then about a week or so later, I got what was without question the nicest rejection letter I have ever received in my career. I'm sure it's someplace in some file somewhere, and so I probably should have dug it out, but it would have taken way too much time going around the attic trying to find it. But I got done reading the rejection letter and felt better about myself than I usually do if I get an offer from someone. So it was quite remarkable. And then what I found out many years later, 20 years later actually, was that as it happened, Justice Powell actually had that morning already given away his 4th offer for a clerkship. It hadn't been accepted yet, but that's not likely to be an open issue for very long, so not surprisingly. And so, but I was coming in anyway, and so we went through the interview process, and I think in part because he probably felt somewhat guilty about the situation, slightly a bait and switch, although still a wonderful experience in its own right. But in any event, what he did was he, that same day, hand wrote a note to Chief Justice Berger. And in the note he said, I've had a wonderful interview with a young gentleman, and I think he would make an excellent law clerk. And while I have filled up my slots, I hope that when you're interviewing, you might give some consideration to Mr. Phillips. What I then also found out at the same time was that Justice Powell had written these kinds of notes 3 times in his tenure and overlap with the Chief Justice, and every time the Chief Justice had said to the clerkship committee, put that candidate at the top of the list. So in a very real way, Justice Powell is directly responsible, one, for my clerkship with the Chief Justice, which I might have gotten anyway, but I wouldn't want to bet on that. And then, but then 2, obviously, a clerkship at the Supreme Court is, if not a necessary starting point to trying to have an appellate career, it's certainly a relatively significant one. So in a very real way, I do think I owe an extraordinary debt to Justice Powell as a consequence of that. The second aspect of Justice Powell that seems to me quite relevant, at least in my appellate career at this stage, is that when I received the Lewis F. Powell Award from the U.S. Chamber of Commerce last year, I found out that Justice Powell had been instrumental in convincing the U.S. Chamber of Commerce that it needed to upgrade significantly the quality of its advocacy before the Supreme Court. Justice Powell basically ranked categories of advocates before the court, and he said states are at the very bottom of the list. Their attorneys general should never be allowed in open court. But businesses are not significantly above that, and a lot of the business lawyers who show up, some of whom I think came from New York, it might have been a bit of a culture clash there, but in any event, didn't do significantly better, didn't seem to be particularly responsive to the needs of the court. And then there was the United States government and the Solicitor General's office, which had significant expertise because they're the lawyers who come back routinely and handle cases in front of the court. And so he said to the Chamber of Commerce, you need to do something to upgrade the quality of this. And then he went one step further than that and sat down and had a conversation with my former mentor and partner and my boss when he was the Solicitor General of the United States, Rex Lee. And he said to Rex, when you leave the Justice Department, you should go into private practice and you should do everything you can to create a specialized, dedicated appellate practice, and if possible, aim it at the Supreme Court in order to upgrade the quality of the business advocacy before that court. Well, Rex, being an extraordinarily intelligent person, followed Justice Powell's advice, and when he came to Sidley, my own firm, and joined us, we joined the firm, that was his mission. And Sidley, I would argue, became the first firm to have a dedicated Supreme Court practice. And it was, again, it may be something we would have done anyway. Rex might have come to this conclusion on his own, but I think there's little question that Justice Powell's influence in terms of pushing us in that direction has gone a long way toward you wanting to invite me here, because obviously I think if I didn't have a substantial Supreme Court practice and was just practicing in Washington, D.C., maybe you'd invite me, but maybe you wouldn't. And so again, I think I owe a very significant debt to Justice Powell on both those counts. So when I got the invitation from Ryan to come and speak in honor of Justice Powell, it was candidly a very easy yes to say, subject to my wife, who has to approve all of my speaking engagements because I travel so much. I don't like to go out too far without, and fortunately she's here today, and we're very happy to be here. What I thought I would do is spend a little bit of time, and I hope there'll be time for questions and answers, as I've said to several people before. I mean, ordinarily nobody has to listen to me speak for longer than about 1.5 minutes to 2 minutes, because by then somebody's interrupting me and then the flow is gone. And that's actually probably a better way to listen to me speak anyway than just having me blather on. But I'm going to try to make a few substantive points that I think are worthy of comment as an advocate before the court. But I would welcome and I'm going to leave a substantial amount of time for questions, which I hope at least there will be a few. But the topic I want to talk about, and it does relate to Justice Powell's judicial decision-making philosophy, is the debate between the basic approach of incrementalism and unanimity, the notion that it is better to have 9 justices agree on a ruling, even if it only decides the very specific facts before the court and moves the law very little, as opposed to a much more divisive 5-4 ruling that may state a rule or principle of law that is significantly broader or perhaps has a brighter line. And this is a debate that you see pretty regularly because Chief Justice Roberts, both in his confirmation hearings and in a variety of speeches since then, has pretty consistently said that he favors unanimity and incrementalism. A quote from his confirmation hearings that one of the things that the Chief Justice should have as a top priority is to try to bring about a greater degree of coherence and consensus in the opinions of the court. Now, at least arguably, coherence and consensus may or may not necessarily lead to conflicting or concurrent outcomes. Again, the need to get 9 justices to agree to any single proposition, almost by definition, ensures that that proposition is free from controversy. And as a consequence of that, it may not provide much more than a limited decision on the specific facts of the case and the problems that follow from that. And therefore you get sort of the least common denominator. I think in many ways Justice Powell would have embraced that notion. I think he was by far more inclined toward an incrementalist approach oftentimes, and I think a lot of that's driven by the fact that he was the swing vote. And in the scheme of things, I suspect he would have been a much happier justice not being the pivot. I mean, I'm sure there are times when it's lovely to be the 5th vote where you can essentially dictate the outcome of the case. You know, I'm sure there's some exhilaration from being the swing vote in Bakke. On the other hand, you might well wonder whether you want all of that kind of intense scrutiny on you every day, and that maybe it's better if you can bring all the 9 together and therefore not have to worry about it in the same way. I thought but the other side of that coin, and it's espoused largely by Justice Scalia, is that he believes that it's much more important, obviously, to have bright line rules, even if they happen to come at the cost of 5-4. And indeed, if you go back a generation, you know, Justice Brennan used to say pretty regularly, you know, if I have 5 votes, I can do anything. And he certainly believed that, and there's a lot of evidence that supports that, so that if you look at the sort of criminal procedure revolution back in the 1960s, a lot of that, in the 1970s, a lot of that is driven by 5-4 decisions where Justice Brennan was instrumental in getting the 5 together, announcing you know, bright line rules, obviously in a liberal direction, but doing it in a way that you know, advances the law significantly. You may agree or disagree on those outcomes, but there's little question that they significantly advance the law. My position as an advocate is that I frankly would far prefer 5-4 broader decisions that provide bright lines. There are exceptions to that I'll discuss, but I want to talk a little bit about the problems that arise when you go for unanimity as opposed to trying to decide a case. And I'm going to primarily focus on 2 examples, neither of which is a particularly interesting case, so I'll concede that up front. One's a patent case, but it's pretty easy to understand, and the other one is a case I argued on Tuesday, so not surprisingly, it's sort of uppermost in my mind at this point, but I think I could have used almost any case I've argued in the last several years and could have illustrated essentially the same point. But in the eBay case, a couple of terms ago, the decision of the court was 9-0. And it was a very narrow decision. The Federal Circuit had historically adopted the rule that any time there is proof or a finding by a trier of fact that a patent is valid and infringed, the patent holder automatically is entitled to injunctive relief to oust the infringer from infringing the patent. The statute that's involved in this particular context, Section 285, specifically says that the district courts are invested with discretion to decide whether or not to exercise equitable relief. And so it's reasonably clear to me, as an outside observer of patent law, that the approach of the Federal Circuit is actually quite inconsistent with the language of the statute. And ultimately, Justice Thomas wrote an opinion for a unanimous court that said essentially that this notion that you automatically get an injunction is flatly inconsistent with the statute. Now, that's a 9-0 decision, and it's quite narrow. All it says is, it doesn't say anything about under what circumstances should you issue an injunction, should you be reluctant to issue an injunction, should you be enthusiastic about it. There's nothing in the opinion on it. It's an 8-page opinion that simply says the Federal Circuit misread the statute. There are 2 concurring opinions. Now, I think maybe the Chief Justice in this context would say we would have been better off with the just simple 9-0 Justice Thomas opinion. But it's hard to say that because he wrote one of the 2 concurring opinions. And the 2 concurring opinions, the one he wrote said that going forward, lower courts should recognize the historic justification for injunctive relief was to provide extraordinary protection for patent holders. And therefore, district courts in the future, while they shouldn't automatically grant an injunction, should nevertheless essentially be very presumptively inclined to grant an injunction in order effectively to protect patent rights. And he wrote that opinion for himself and 2 other justices. Justice Kennedy wrote a separate concurrence in which he took a very different position, which was that the district courts ought to be quite skeptical about issuing injunctions in these cases. And the reason was that times had changed. History wasn't such a good guide in this context. And there are a lot of situations where, and he talked about patent trolls, which I could spend a minute or 2 talking about if you'd like. Patent trolls are individuals usually who go and find patents and then try to figure out if somebody is infringing that patent and then sues. So they don't actually make anything, they don't invent anything, they don't make any product, they simply live to create litigation, which, look, I'm a litigator, so that's not necessarily a bad thing, but from the court's perspective, which has to service all of this litigation, they may take a slightly different view of that. But his basic take on it was, look, if you have a pretty narrow patent that happens to speak on or act on a much more complicated process, and you say, okay, you're automatically entitled to an injunction, which may stop that entire process, which could be worth tens or hundreds of millions, billions of dollars, who knows. What you do is you give the patent holder enormous leverage, way out of sync with any inventive value that's embodied in that particular patent. And under those circumstances, Justice Kennedy said, courts ought to be very reluctant to grant injunctive relief. They ought to recognize that there's no particular value here and therefore provide as a remedy money damages, which is a perfectly valid way of pursuing it. The point here is to sort of say, to my mind at least, the case demonstrates as clearly as anyone can the difficulties embodied if you have a 9-0 unanimous opinion. Because again, if you'd had just Justice Thomas's opinion, all you would know if you were a district court and if you were a litigant is that, okay, from now on you're not entitled to an automatic injunction. That has significance, to be sure, but it doesn't necessarily answer the question of, okay, what do I do next? And of course, now you have these other 2 opinions. Neither one speaks for a majority of the court, one of which says, be leery about issuing injunctions. The other one says, be enthusiastic about issuing injunctions. And so what do the lower courts do? Just as an empirical matter, in the wake of eBay, the lower courts have more often than not declined to grant injunctions. Federal Circuit has not had a chance to revisit that issue. But basically what they're doing is some lower courts are saying, I like the Roberts approach, or I think this is a case that sort of falls more into the historic traditional approach. And other courts are saying, I like the Kennedy approach, and others come out. What do we know from this? Well, the one thing we know for sure is that this issue is coming back to the Supreme Court. I mean, if nothing else, Justice Kennedy, speaking for 3 other justices in the certiorari process, this goes to the limits of my math skills. You need to count to 4 because that's how many you get to get certiorari. You need to count to 5 to win. I've now exhausted my arithmetic skills. But the reality is, that case is going to come back. So in one sense, I can say, as a litigator, I can only hope that whenever the case comes back, whoever is going to hire counsel will remember who argued the eBay case and won. actually, because otherwise one of my competitors is going to get this case, and that would be bad news. But if I'm a litigant, and I'm sitting there, I'm saying to myself, wouldn't I be happier if the court had resolved the differences between Justices Kennedy and the Chief Justice? I mean, it's nice to have identified the problem, but wouldn't it have been nice if the justices had gone ahead and finished it and had Justice Thomas and Alito decide which of those two ways to come out? Now, in that context, I think it's fair to step back a second and recognize that case came up right at the tail end of the first term when Justice Alito had joined the court in the middle of the term. And so he was literally trying to catch up on the fly as they went along. And it's reasonably clear to me if you look at the statistics from the 2005 term, which was his first, tail end of that first one. There are far more unanimous opinions in that term than certainly in the term afterwards, and even in terms before and after that. And so there must have been some kind of internal agreement that they were not going to force issues to be resolved on a 5-4 basis. The next year, actually, the court had a significantly larger number of 5-4 cases. It was significantly more divisive as a consequence of it. The last two terms, it seems to me, there's probably been a little bit of a step back from deciding some of those more divisive issues as it goes forward. The two fundamental values that come from a clearer ruling from the court are, one, it affects the settlement of cases. If you know what the law is, the litigants can in fact reasonably settle based on what they expect the courts will do. If you don't have clear principles, then the incentives to litigate to the end of time are great. As I say, as a litigator myself, that I could see the other side of that, but I think from the purposes of sort of social value, the court does better when it actually rules more conclusively on a 5-4 basis. The other problem that arises, and you see this candidly in the wake of the eBay case in patent law generally, is it leads to really extraordinary forum shopping, because certain courts are going to move in a particular direction, and so those that are going to give you injunctive relief, the plaintiffs are going to run there. Those that aren't going to give you injunctive relief, the plaintiffs are going to run away from, and the defendants are going to fight to try to get those cases transferred to those jurisdictions, and so you end up expending enormous amounts of time and energy and money over where you ought to litigate a particular issue rather than getting to the resolution of the case. So that to me is probably the most compelling reason for trying to come out with clearer rules from the court that provide greater guidance to both the litigators and to the lower courts. The second case that I'd like to spend a little bit of time illustrating the difficulties from an advocate's perspective is the case I argued on Tuesday, which is FPL Federal. It's Gross versus FPL Federal. And again, I don't want to give you too much of a tutorial on employment discrimination law, because my guess is most of you are not going to be employment discrimination lawyers, but nevertheless, a little bit of background is necessary in order to put it into perspective. And the purpose here, again, is to show you the difficulties you have both as a litigant and as a litigator trying to deal with narrow versus broader decisions from the court. In order to put this into a bit of perspective, 20 years ago, the Supreme Court decided a fairly important employment discrimination case called Price Waterhouse. And in Price Waterhouse, it was a Title VII case. It was sex discrimination. Price Waterhouse, a large accounting firm, and a woman had been denied admission to partnership. The Price Waterhouse uses a committee to make these decisions, and each partners who know the candidate submit. This is going to sound a lot like law firms. Submit their evaluations of the candidate, and a lot of these comments that were put forward involved gender stereotyping. And so the question was, in that circumstance, was there a violation of Title VII's prohibition against sex discrimination? And interestingly enough, Justice Brennan wrote for a plurality of the court, not for the court itself. This is one where he didn't figure out how to count to 5. So he wrote for 4 of the justices. And the core question as it came to the Supreme Court involved whether or under what circumstances, if any, does the burden of proof shift from the plaintiff to the defendant in an employment discrimination case. So here you had a situation where There were some comments that evaluated the candidate on the merits, said that she was not particularly effective at her job, and there were other comments that seemed to suggest that there was some sexual stereotyping going on. And you had a multi-member body that was making the decision. It was hard to tell which of the various comments ultimately would have led to the outcome that happened. Judge Gerhard Gazelle, who was a wonderful district court judge in the District of Columbia, tried the case and concluded in the first instance that there was enough evidence to show that gender was a motivating factor in the decision. He then shifted the burden of proof to Price Waterhouse to demonstrate that notwithstanding those considerations, that Price Waterhouse nevertheless would have followed the same course and would not have promoted her to a partnership, therefore shifting the burden of proof to the employer. But they also said, and Price Waterhouse has to show that by clear and convincing evidence, which means he raised the standard of proof beyond the preponderance evidence that's traditionally used in civil litigation. The case was affirmed by the D.C. Circuit, and certiorari was granted by the Supreme Court at Price Waterhouse's request. Now, I think if you take Chief Justice Roberts' admonition that to decide issues narrowly in a serious vein, you probably would have decided Price Waterhouse solely on the theory that elevating the standard of review for after the burden of proof had shifted to clear and convincing evidence was wrong. And because all 9 justices shared that opinion. They all said that was a mistake. And candidly, you could have simply knocked that off, vacated, remanded, not decided the question of shifting burdens of proof, not decided anything about that, left it open. Obviously, well, not obviously, but there were in fact differences of opinion among lower courts at the time. And so the issue is, are we better off in that situation or what the court actually did? And what the court actually did is 4 justices speaking for a plurality, and Justice Brennan writing the opinion said it was perfectly appropriate once the plaintiff had shown that gender was a motivating factor to shift the burden of proof to the defendant and then let it go at that, but then said, but the higher standard of proof was wrong. Justice White wrote a separate concurring opinion, which I can fairly say is incomprehensible. As much as I like Justice White, I have to say this is not one of his better opinions. That sort of says, he agrees some with Justice Brennan, he agrees some with Justice O'Connor, I'll mention her opinion in a minute, and says, I think this is a case like another case, Mount Healthy, where we shifted the burden of proof. And so, on the whole, I'm happy. But he doesn't join the plurality opinion, and so he doesn't provide the 5th vote for that. Justice O'Connor, by contrast, writes what I thought was actually a quite interesting opinion. It at least had the benefit of being able to be read and understood. You could disagree with it, and you might say it's sort of untethered to the statute itself, but at least you understood what she was doing. And basically what Justice O'Connor said was, I'm not keen on shifting the burden of proof. We've said in a lot of other cases that the burden never shifts from the plaintiff or to the defendant, and I think that's generally the right rule. But there are going to be some cases where I think it ought to shift, and this is one of them. And the reason is because I think that in this context, where gender was a substantial factor, and where there was direct evidence that gender was a substantial factor, in that circumstance, then the burden of proof should shift to the defendant. But, of course, the court below erred by upping the standard of review and vacate and remand. Justice Kennedy wrote a dissenting opinion in which he said, we've said the burden of proof doesn't shift. Why is the burden of proof shifting here? The statute says because of. That says you're going to have to show but-for causation. You didn't do, and you haven't shown that, or at least that's not what the district court held. He shifted the burden of proof, and so there's a dissent. He wrote that for Justice Scalia and at the time Chief Justice Rehnquist. So, what do lower courts do? What do litigants do in the wake of that? First of all, you have no opinion for the court. So you don't know what the plurality opinion is. As it happens, Justice O'Connor's opinion became the sort of consensus view. And again, I think it's largely because lower courts could read it and at least understand the principles. You could attach the words to them. What is a substantial factor? What is direct evidence? Perhaps not exactly the easiest terms to apply in ordinary circumstances. And it's fascinating to watch over the course of the 20 years after Price Waterhouse. First of all, there are literally hundreds of cases on this topic, and there are, in some circuits, 3 different interpretations of Justice O'Connor's opinion. In other circuits, 4 different interpretations. And circuits have decided to just sort of let it go rather than try, because there's no point in trying to reconcile all of this. So 2 terms ago, in the Costa case, the Supreme Court finally revisits Price Waterhouse. It comes up in the Title VII. Oh, before I get to that, let me say one other thing. Intervening, okay, we've got Price Waterhouse, comes down in 1989. 1991, Congress amends Title VII. Okay, that's good. And it says in a Title VII case, a true Title VII case, that what happens is if gender, race, any of the protected classes is a motivating factor, using the same language that the plurality adopts, then liability attaches to the employer in that circumstance. And the employer is permitted, as a sort of modified version of an affirmative defense, to come back and say, yes, but we would have made the same decision regardless of gender. And in that situation, that limits the remedies that are available to the plaintiff. It doesn't eliminate liability, but it does reduce the back pay that you might otherwise be required to pay. So that Congress makes that decision. But Congress only amends Title VII in the 1991 Civil Rights Restoration Act. It doesn't amend any of the other employment discrimination statutes, the age discrimination, the Americans with Disabilities, it doesn't do that. But interestingly enough, in other provisions of those amendments, it makes conforming changes in the law that apply to both Title VII and to the Age Discrimination Employment Act, which leaves you with the inference that Congress must have intentionally distinguished between race and gender discrimination and other forms of discrimination in deciding when the burden of proof should shift. So now we come to 2 terms ago in the Costa case. And in that context, what had happened was the employee had been fired, and again, alleging that on the basis of gender, and the district court applied a motivating factor, shifted the burden of proof, and the case went to the Ninth Circuit, and a panel of the Ninth Circuit reversed on the grounds that applying Justice O'Connor's direct evidence test, the evidence involved in this case had been circumstantial as opposed to direct evidence, and therefore that they were not entitled, that there was no shifting of the burden of proof. Okay, that's, the Ninth Circuit then en banc overturns the panel decision and announces the rule that no, direct, circumstantial, that cannot be a meaningful distinction, because you can convict people for crimes on the basis of purely circumstantial evidence. The idea that somehow circumstantial evidence is unavailable as a basis for shifting the burden of proof in an ordinary civil litigation is nuts. So, but the Ninth Circuit recognized that decision was flatly inconsistent with a lot of other circuits that were interpreting Justice O'Connor's opinion. And again, the problem here is, what does direct evidence mean? Does it mean circumstantial, not circumstantial evidence? Does it mean evidence that doesn't require any inferences? Does it require just a stronger amount of evidence? What does it mean? It's hardly self-defining, and as I say, the lower courts were all over the lot. So the Supreme Court grants certiorari in this case. And so the world is saying, okay, we're going to finally find out what's the right answer. What does direct evidence mean? Is Justice O'Connor's opinion the opinion for the court, or are we going to resolve it? And what do we get? We get a 9-0 opinion from Justice Thomas, in which he says that we don't have to decide that issue because the 1991 statute amended Title VII, and it eliminated all of this nonsense. It changed the whole Price Waterhouse formulation, and it substituted this completely different scheme in which you don't have a defense to liability. You have a statutorily prescribed standard that gets applied, a statutorily prescribed mechanism for proving it, and then a statutorily prescribed method for deciding how to apply the affirmative defense that Congress had provided for, and therefore we don't have to decide any of those questions. Now I think actually this is an excellent illustration of reaching agreement in a unanimous way that probably was the right thing to do, because clearly the court would have been really stretching to make a decision about non-Title VII cases and what standards should apply in a non-Title VII context in a purely Title VII case that has its own statutory scheme. But again, of course, you still have this enormous conflict out among the courts of appeals, extraordinary disarray at this point, and it's not likely to go away, in part, I suppose, because the Title VII is one thing, but you still have the Age Discrimination and Employment Act. I suppose the good news, again, as a litigator is as long as you have open issues out there, sooner or later they're going to make their way back to the Supreme Court. And the FPL federal case that I mentioned a second ago is the next case where the court now has the opportunity. FPL federal arises in the context of an adverse employment decision where an employee is demoted on the basis of age discrimination, or at least claimed age discrimination. There was a reorganization of the company. A lot of additional people were brought in. Some people's jobs changed. This particular gentleman was 56 years old. Most of his assignments were kind of shifted in other places. He was given a somewhat indeterminate job. Even though his compensation wasn't reduced, his opportunity for future raises was. And as a consequence of that, he sued the employer and claimed that he was the victim of age discrimination. After the trial, the trial judge gives the instruction that the plaintiff asks for, which is the Title VII instruction, a motivating factor, which actually is then further defined as saying if age played a part or any role in the decision, then the burden of proof shifts to the defendant to demonstrate that the adverse employment action would have been taken under the same circumstances. And so that issue now leads to, and under those jury instructions, the jury in fact rules in favor of the plaintiff, gives him about $50,000. The case goes to the Eighth Circuit. I'm still sort of mystified, candidly, that we're litigating this in the Supreme Court over $50,000, but that's a separate issue. We can talk about that at some other point in this process. But the Eighth Circuit reverses. And the Eighth Circuit says, look, the rule in the Eighth Circuit is Justice O'Connor's direct evidence standard. Now, the court specifically defines the direct evidence standard as meaning a strong link between the evidence and the discriminatory action. Now, what strong link means is not altogether clear to me, but whatever it means, it didn't exist in this case, so they set aside the verdict and sent it back. Again, as I say, there's a disarray in the lower courts. The case makes its way to the Supreme Court. Now, the only tricky part about this from my perspective is that when the case was granted over my client's opposition, you might say, well, that would have been about the right time to hire me to handle this particular case. They decided not to bring in new counsel at that point. And when the other side filed its brief, and the Solicitor General on behalf of the United States filed a brief on that side of the case, that might have been a nice time to retain my firm to come in and help on that case. But instead what they decided to do was wait until the Thursday before the brief was due on Tuesday and call me up and ask me if I'd step in and help them both with the brief and to argue the case, which was only slightly complicated for me because I had an argument on Monday in the Supreme Court. So it wasn't as though I could say, oh, I've got boatloads of time to figure all of this out, although fortunately I have wonderfully talented partners who actually know this area of the law a lot better than I do. And so we undertook to help them out and filed the brief under these circumstances. And obviously now I'm going to sort of evaluate this case, and I have no idea what the Supreme Court is going to do other than you sort of have some sense after an oral argument as to kind of where the leanings are, and we could talk about that some as well. But in front of the Supreme Court, the issues are, what is the narrowest basis on which you could reach a decision in this case? I'm going now back to the Chief Justice's admonition, or his principle, guiding principle of preference. 9-0, coherent, what do you say? Well, the narrowest basis on which to decide the case is to say that you thought that the Eighth Circuit was distinguishing between circumstantial evidence and direct evidence. And all of us agree that that's not a distinction that makes sense. And the court said that 2 terms ago anyway. And therefore, we vacate the Eighth Circuit, send it back, let them decide the other issues that had been briefed before the Eighth Circuit up to that point. The problem with that, of course, is that doesn't decide this case because it doesn't appear to be the distinction that the Eighth Circuit really meant to be elaborating. But 2, it doesn't resolve any of the differences among the lower courts. There may be one court that has in fact bought the circumstantial versus direct evidence distinction, and I'm pretty sure it wouldn't come to the same conclusion today anyway. But if you really take seriously the idea that we should try to decide cases as narrowly as possible, that would be the basis on which you do it. And I have to tell you that as an advocate, this preference and this approach affects how you litigate these kinds of cases. Because the one thing you have to be worried about, and it's even more important when you're in March and April, but what you really have to be worried about is the court going to try to find the lowest common denominator basis on which to decide the case? Now you say, why does it make a difference that it's March or April? And the answer is pretty easy. Court gets done with all of the opinions by the end of June. So if you're arguing on April 30th, court's got about a month to get the opinion done. And then the dissent's got 2 more weeks. Not a lot of time in there. You know, there's this wonderful comment from Chief Justice Rehnquist many years ago that the time to think is ended and the time to start writing has begun. And there is some truth to what he suggests in that. At the tail end of the term, you get a race to judgment. So if you're sitting there as I am in March worrying about where the court may come out, the narrowest basis is there. So it affects how you write the brief. You write a brief that says that shouldn't be the basis on which this case is decided, because it doesn't decide this case and it doesn't help the lower courts whatsoever, although you have to worry about how the court's going to evaluate it. But assuming then that they don't decide that issue, then the question is, what's the next kind of narrowest issue? Well, you know, there is at least one on my side. And again, as an advocate, you want to put it forward because you want to have the same benefit, which is, look, if you're not going to spend a lot of time thinking about this case, why don't you think about it in the narrowest way that I could win on, which is, you know, from my perspective, a good thing. And so what we argued was, you know, you can take Justice White's opinion, which otherwise doesn't make a lot of sense to me, but does say that something has to be a substantial factor. And whatever substantial factor means, and I have no idea what that means, is different from a motivating factor that means just a part or a role. So even if you use Justice White's formulation, the jury instruction here was wrong, and therefore they shouldn't have shifted the burden to the defendant, and therefore you can affirm the Eighth Circuit on that basis. Again, recognizing that ruling achieves nothing other than I win, which, you know, okay, that achieves something. But it doesn't achieve anything for the general purposes of the court, or what it's seeking to accomplish here, or at least if it purports to be not just a court of errors, which it says routinely, and as a court of law, which means it's supposed to be stating principles that are more valuable and provide more guidance. You know, winning's great, but that, again, I think would be a general disappointment to the bar and to litigants going forward. So then the question is, what's the next logical point in this context? And that is to try to figure out, what does direct evidence mean? You know, is Justice O'Connor's opinion really the opinion of the court? And what does direct evidence mean? Now, in one sense, you could say that's a fool's errand, because who cares what Justice O'Connor meant by direct evidence, because she was only talking for one justice. No other justice on the court embraced that particular approach. And so why should the Supreme Court, 20 years later, looking at this, say, okay, let's try to figure out what that opinion meant, rather than just say, look, why don't we just start over and figure out under what circumstances, if any, you should shift the burden of proof. And obviously in that context, my argument is you shouldn't shift the burden of proof. My colleagues on the other side would say that you should. But obviously in that context, I am asking the court to revisit a substantial part of what they did in Price Waterhouse. That, of course, gets you into all kinds of stare decisis issues, and whether the court, you know, and what stare decisis effect there is for a plurality opinion, when you know for sure at least 6 justices clearly thought under some circumstances you ought to have a shifting burden of proof. And there'll be a whole, and we'll see what happens. I will tell you from my perspective on the oral argument that it did seem to me that there were 5 justices who seemed concerned about the notion of whether Price Waterhouse got it right and how you sort these issues out. And there were 4 justices who seemed quite clear that whatever else was going to happen, I think our client shouldn't be winning in this particular case. So we'll see how this plays out. We may find out as early as tomorrow whether or not the court wants additional briefing, because one of the exchanges between Justice Ginsburg, who I unfortunately referred to as Justice O'Connor during the argument, which is another great moment in my professional career, asked me several times about, didn't I think that the case might benefit. Well, first of all, she asked me why I didn't raise this earlier in the litigation, which, you know, you can't say, because I got into the case 2 days before the brief was due, but, you know, it came to my mind, but I didn't say it. You know, I apologize for not raising it sooner, but she said, don't you think this might benefit from additional briefing? And I said, Absolutely. I got 2 days to write the last one. Give me a couple of weeks, God knows what I can come up with. So anyway, I was more than happy, but I mean, she was primarily suggesting that maybe the Solicitor General would have input into this decision that might be particularly beneficial. And so I said fine. And so tomorrow is when the court will consider at conference what to do in this case. And so it's quite possible if the court wants supplemental briefing on this particular issue, we may get an order tomorrow. If not, it'll be interesting if nothing else. We know by the end of June what the court will do with this particular case. In any event, to go back to sort of my basic theme here is that I do think in general what this shows is obviously plurality opinions are anathema. They are. The court should never, if the court couldn't come up with a 5-person outcome in Price Waterhouse, it should have just decided on the narrowest basis, on the narrow basis. It really, I mean, because what it has wrought by not coming out with a 5-4 decision is enormously complicated and very expensive, thousands of hours. Lord knows how many trees have died as a consequence of the failure to do that. Indeed, you could make a pretty good argument that employers would have been much better off if in Price Waterhouse, Justice Brennan had in fact gotten that 5th opinion, because then at least you would know precisely what the rule is, and it would have, I think, guided litigation going forward. Indeed, if you look at Title VII, where Congress has in fact come up with a specific formulation of it, there are far fewer disputes these days than there were, certainly than there are in the context of the Age Discrimination and Employment Act. So that's part of it. The other part of it is obviously, how it affects the way you have to litigate before the court, because you have to think about which way is the court going to go. Is it going to focus more narrowly? Is it likely to focus more broadly? And what buttons do you push, and which justices are likely to want to respond in one way or another? I thought I would close on a lighter note, and it goes back to Justice Powell. One of the worst fears of any oral advocate is the notion of being quoted in a Supreme Court opinion as having conceded away the case. And the only time I have ever been quoted in an opinion of the Supreme Court was an opinion by Justice Powell in a case called Port Arthur, Texas versus the United States. I was a very young lawyer in the Solicitor General's office. It was my 3rd case. The issue involved Section 5 of the Voting Rights Act, and the issue was whether or not Port Arthur had annexed, and when it had annexed certain property, whether that annexation should have been subject to Section 5 of the Voting Rights Act, and the requirement that you pre-clear or get approval for that particular action from the Attorney General in the Justice Department. And I was representing the United States, so I was obviously arguing that it was subject to pre-clearance, and the reason was because there had been a discriminatory effect. And Justice Powell, and one thing I should say about Justice Powell, he did not ask a lot of questions at oral argument. But if he asked you a question, it pretty much told you what he was thinking about your case. And so if he had concerns, and since he was the swing vote in a lot of cases, you listened real carefully. He talked very softly, he had that wonderful Southern drawl, but you knew that this was going to be maybe the most important question you were going to answer. Anyway, the following exchange took place, which he reproduces in his opinion in dissent, I might add, the following. This is bracketed, the court. And I won't try this accent, it's too good. And may I get clear, is the purpose still in this case, is the purpose, there's effect and purpose under Section 5. Is the purpose issue still in this case at this level? And then in brackets it says the government, so I'm very happy it doesn't name me by name. My answer is not in terms of the submission to this court, no, Your Honor. I was smart enough in those days to say Your Honor rather than screw up the person's name. So I've not learned much in 20 years of doing this. So then Justice Powell says, so we consider only the effect. And I respond, yes, Your Honor, I don't believe that the district court's opinion or order can fairly be read to cast any doubt on the purpose of the plan as adopted. And then it quotes transcript of oral argument on page 30. And of course, what he said was, Of course, Justice White, writing the opinion for the court, said that he concluded that the purpose of this was in fact discriminatory, which is why the annexation was subject to preclearance. And Justice Powell is writing his dissent saying, how can that possibly be? The lawyer for the United States stood up here and conceded the purpose was not in this case. Now, that's not the kind of concession that you normally worry all that much about, because candidly, I couldn't have said anything different, because the truth is, I didn't think it was in the case. And again, it goes back to the basic point. If you got 5 votes, you can pretty much do or say whatever you want, and Justice White had 5 votes in that particular case. And as I say, I still am happy that that comes in as under the rubric of the government rather than under Carter Phillips. So nobody can look that one up and Google me for that particular problem. As hopefully you can tell from this, I admire Justice Powell a great deal, and I had nothing but the highest regard for him. It was a lot of fun to clerk on the court during one of the years when he was still quite active, and clerking has the disadvantage of in a lot of ways, sausage making. When you see the process, it looks a lot uglier than if you just see the final work product. But it's nevertheless, if nothing else, eye-opening. And watching Justice Powell maneuver as the swing vote during my term as a law clerk was inspiring, if nothing else. Although there were times when you just marveled at his ability to kind of work through problems with the other justices. And in those days, I think there was much more interaction among individual justices than there was during Chief Justice Rehnquist's tenure. I think they may be going back to it now more. But he was a wonderful person. I owe him an enormous debt. It has been my privilege to be here to speak in his honor. It's a wonderful program, and particularly meaningful to me because it's put on by the students. Thank you for inviting me, and I would be more than happy to entertain any questions that people have about either any of the things I talked about substantively, which I'm told you'll be able to read about in the law review one of these days, or to talk about anything dealing with the court. Thank you.